Good morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, or we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sex with girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or a proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing, that mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's Just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done.
I wonder why Karen keeps getting that reaction. Probably because everyone who hears the story she's trying to sell them walks away thinking the same thing that she made the whole thing up.
The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th, statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation.
Oh, someone is absolutely going to be held accountable for their actions today. It just won't be her ex, Karen.
That's all.
Okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings. Obviously, you're well aware of the file in this case. The court does believe that the plaintiff has met the VARCA threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay, Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure, we'll keep it straight and to the point here. Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No?
Well, that was straightforward. If you're not going to challenge his testimony, then the court has no choice but to accept it as fact. The next witness called will be his mother.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
you heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I
parenting
do.
time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park. And we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach. And we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time that stated that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay, Ms. Couch, do you have any
I
questions of
do,
this witness?
yes. At what age did Zach Conley start wearing diapers?
Why exactly would it matter when your ex started wearing diapers? I think it's pretty safe to assume it was sometime after he was born.
Earth.
And Judge, I'm gonna object to it.
Ma'am, that is not germane.
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay?
Okay.
Go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Even though the order was for the 29th. Wasn't that the
Whatever,
order that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And,
you slammed the door in my face. I have it on video, yes.
and you came alone, correct?
I did that day,
Okay.
yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some, Ms. Couch, you raised some issues concerning the I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
And why is that?
Because he our children, and I don't believe that he needs any more parenting time.
Okay. You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
Yeah, I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
If new orders were issued following a denied ex parte order, then those new orders are the ones that must be followed, even if you've somehow convinced yourself that the man you chose to have multiple children with has magically turned into a bad person overnight.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you have not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So
let's break down where you stand right now. Every report on record says the father did nothing wrong, and the only thing contradicting those reports are vague personal statements from the very same people who filed them. In other words, the gavel has spoken, and it did not speak in your favor.
okay, Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit. This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With a threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We'd request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's voiced she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank
Okay,
you.
thank you. Ms. Couch, your closing argument.
I am acting in I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of,
But there's reason, sir.
excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with.
So she's refusing to comply with court orders. And let me go ahead and predict what comes next. She's not going to quietly accept the consequences heading her way either. Shocking. Truly shocking.
The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you've paid the previously ordered attorney fees of $1,000. So,
all right, let's talk about what the court just dropped. She's been hit with 30 days for contempt, and she isn't walking out of that cell until she does 2 things. She hands those children over to the father so he can exercise his parenting time, and B, she cuts a check for $1,000 in attorney fees for dragging this man back into court time and time again without cause. But here at Gavel and Verdict, we're not done yet, because there's more.
ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's
Have a good
sucking
day.
whose dick around here?
Oh,
No,
ma'am.
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am.
Clip 9, and just like that, she's added another 30 days to her tab for contempt of court. The gavel came down, the verdict was delivered, and for the first time in what feels like a long time, the right person faced the right consequences. Justice at last. If you found this video helpful, hit that like button. If it wasn't for you, the dislike is right there too. Drop your thoughts in the comments below, and make sure you subscribe with notifications on so you never miss a verdict here at Gavel and Verdict. We'll see you in the next one.